Doesn't matter, nice night.
Yeah.
Nice when it was Thursday.
Yeah.
Exactly.
Yeah.
Thursday.
All right, you're on record.
All right, thank you, Nora. Today is June 20th at 7:30. Welcome to a meeting of Township of Parsippany's at Troy Hills Planning Board meeting. Announcement is made that adequate notice of this meeting is being given and is being conducted in accordance with NJSA 10:4-6 et sec of the New Jersey Open Public Meetings Act. Please call the roll.
Mr. Didich?
Here.
Mr. Dinsmore?
Here.
Mr. DiPiero?
Here,
Councilwoman Hernandez?
Here.
Mr. Napolitano?
Here.
Mr. Patel?
Here.
Mr. Shaw?
Here.
Ms. Smith?
Here.
Chairman Von Aiken?
Here.
We have our board planner, Mr. Ryerson.
Here.
Our board engineer, Ms. Knust.
Here.
And our board attorney, Mr. Wenzel.
Would everyone please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This meeting is open to the general public. Is there anybody from the general public who wishes to bring something before this board which is not on the agenda for this evening? Seeing no one, I will close the public portion and move on to our agenda for this evening. The item on the agenda for tonight is application 26:506. Is the applicant present?
Yes, we are. Good evening, Mr. Chairman, members of the board. Stephen Tombolaki from Winter Group Parsippany. On behalf of the applicant, Nakul Kasadwala. We're here this evening for a minor subdivision with some bulk variance application involving a residential lot at 289 East Halsey. This evening, we're going to have two witnesses. We have Frank Matarazzo, the engineer who designed the subdivision, and then, when he arrives, John McDonough or his designee will arrive to provide professional planning testimony. So if the notice is in order and the board has jurisdiction, we'd be happy to proceed.
That's fine. Let's start with our waivers. Make sure everything's in order. There are no waivers. Okay. So then I guess we won't ask if we need approval of the waivers, and we'll just turn it back over to you, Mr. Palakian.
Thank you very much. I'd like to have my major Frank Matarazzo sworn.
Mr. Matarazzo, do you swear affirm tell the truth for this planning board tonight?
Yes, I do.
All right, can you do us a favor of stating and spelling your name for the record?
Frank Matarazzo, M-A-T-A-R-A.
Bring the mic closer.
Frank Matarazzo, M-A-T-A-R-A-Z-Z-O.
Okay, and Mr. Matarazzo, why don't we get your qualifications on briefly?
Sure. I hold a Bachelor's of Science in Civil Engineering, also one in Land Surveying from New Jersey Institute of Technology, licensed professional engineer and land surveyor in the state of New Jersey.
And you've testified before multiple boards?
Yes.
Okay, and your license to practice in the field of civil engineering in the state of New Jersey is current and up to date, correct?
Correct.
Did you check your email today? No. Just wanted to see if you were paying attention. Okay. So Chair, through you, we'll accept Mr. Matarazzo and his extensive background in the field of civil engineering as an expert.
Any questions from the board? All right, seeing none, we'll move forward. Witness is acceptable.
Thank you very much. Mr. Matarazzo, since you designed the subdivision, can you provide the board an overview of the property, its existing state?
Can you use the
Steve,
microphone,
you gotta
please?
get closer.
Thank you.
Yeah, provide an overview of the property, its existing state, and then provide the board the benefit of the proposed subdivision, the design that went into it, and what is contemplated to be, once the subdivision is complete, what is the applicant's intent?
Sure.
For the future two lots, hopefully.
Sure. Okay, so the site's located on the southerly side of East Halsey Road. It's between Westminster Road and Stafford Terrace. The overall property dimensions are 298.84 feet wide by 237 feet deep. There's currently several structures on the property. There's a two-story dwelling, a swimming pool, a detached garage, and a circular driveway. This site is fairly flat with a mild slope sloping downhill from north to south. Or if you look at from your perspective of the plans, it would be from front to rear. And I have an exhibit.
All right,
Now,
well,
Frank,
this is,
is that exhibit, was it part of the application submission?
Yes, it's a colorized version of the subdivision map.
okay, wait, one second, Steve. So, Mr. Matarazzo, okay, you do have the mic with you, right?
Yeah.
Okay. So, this particular sheet that we're gonna be looking at in a second, the sheet itself was provided, but perhaps it wasn't provided in color, so the one you're showing us now is the one that's in color.
Correct.
Okay, so we'll mark that as Exhibit A1, with today's date. And, you know what, I think since there's, perhaps interested parties in the room, can we turn that slightly? When we get a chance?
But then,
I'm good.
you're good? Frank, we'll give you a change.
She's fully versed.
Stan's memorized. If anybody wants to take a look at it, you're free to,
I think that makes some sense, Steve. Thank you. In Exhibit A1's, one sheet colorized version of the proposed subdivision?
Yes.
Okay.
All right, so, it's sheet 3 of 3. Basically, it shows the existing house, which is to remain. There's an existing swimming pool, which will remain. Proposing a lot line, approximately down the middle of the existing property. Here, the shaded in gray is the, pavement area. There's the existing driveway and a proposed driveway for the remainder lot. So there's two lots, lot 8.03, which is on the east, or from your perspective, the left side of the drawing, and lot 8.02, which is to the right. The lots have the adequate area, lot area. We are requesting a lot width variance, and that's measured along the front yard setback line. We're proposing for lot 802, it's 142.29 feet versus 150 feet, which is the minimum requirement. And for lot 803, which is the one on the left, it's, the front yard, the lot width is 152.44. So it's 2.4 feet greater than the allowable. We struck that line in that position because we wanted to maintain the allowable side yard setback for the existing dwelling. So what's required is a 12-foot minimum side yard. For a dwelling, we're proposing 12.5. So that's what we did. We held 12.5 off the existing house and struck a line down the middle. That's how we came up with that lot layout. So the lot on the left is slightly larger than the minimum allowable, and the lot on the right is slightly smaller.
So, Frank, can you, like, going up maybe to the board, can you explain, in the future, if these lots are subdivided, what is the applicant's intention with respect to removal of certain, site features, placement of a
Yeah.
building envelope, et cetera?
Sure. So there's an existing detached garage, just about in the center of the lot. That will be demolished. There's also a shed located behind the, garage that will be demolished as well. The existing driveway, the applicant wishes to maintain the driveway in its current condition, during construction of a new dwelling on that lot. All right, so if you notice, that driveway kind of goes over the property line, to the lot on the left, lot 803. Just want to maintain that, until, the applicant builds the new house. And he's gonna design it so that, we're gonna apply for building permits with a grading plan. It's gonna have a new dwelling with a new driveway connection. But during construction, he just wants to use that, for construction vehicles, basically.
So am I to understand then that once the construction is complete, then the driveway that's currently residing on the other plot will be addressed?
Yeah, that'll be
Okay.
taken out.
Frank, any encroachments like that driveway, any other encroachments, that will all be eliminated following the construction, correct?
That's correct.
You're not memorializing, making permanent any existing encroachment that might be causing that lot.
That's correct. That's just gonna be maintained until, the applicant constructs the new house and is gonna wind up ultimately constructing a new driveway with a new curb cut and all that.
And Frank, you mentioned that in the future, when the applicant has an architect prepare the building plans, there'll be grading, drainage, all that will be taken care of at that phase of the project design?
Correct.
Can I ask a question?
Sure.
So prior to zoning permits and construction permits, you'll be removing what needs to be removed?
During the permitting phase, you're probably gonna remove the garage first, the detached garage, and the shed in the back. But this part of the driveway, the entrance, will remain.
And zoning, I'm the zoning officer, director, we never issue permits and allow anything to stay. Once the board has approved it and it comes for its zoning permits, everything has to meet at that point. So, because we find that once I issue the zoning permit to get it to return back to what it needs to be, we're approving it as a hypothetical. And then if something's remaining, normally whatever is being approved at the board has to be ready for at the time when the zoning permit. So if you're planning on keeping a driveway that's on the other property, then I have to later try to get them to remove it later. So normally those are things we ask for prior to once you have your plans and once you have your plot plans and you submit to zoning, then anything that needs to be removed would have to be removed.
Yeah, I mean, because that's like a perfect laydown area for the construction, plus, the idea is once the contractor is mobilized and removes that, he could then build the new driveway for the existing home. It would be separate. We're just trying to stop moving dirt twice. So the idea is, again, not to leave it, and we would be more than amenable to conditioning that there would be no CO issued until all those improvements are removed. We just don't want to move dirt twice and want to create a laydown area for the construction, and it's like perfectly located there.
But it's leaving that now up to the construction official to do it at the end when everything's done versus the zoning permit when it comes in the beginning. I'm normally the one that enforces the resolution site plan, not the construction official. So it's usually at the beginning, we try to make sure that everything meets, but I understand what you're doing.
If there's a way we can make it work,
That sounds
that's
good.
great. Thank you. Frank, do you have any additional testimony you'd like to provide the board? I mean, Mr. McDonough's going to provide the support for the variances that you described. But is there any,
Yeah.
regarding Mr. Ryerson and the board engineer's report, is there anything in that report that you disagree with, take exception to, or unable to comply with, et cetera?
There's one comment on page 8, under engineering review, which talks about, map filing law, and preparation of a map for filing. What we're planning on doing is perfecting this subdivision by deed. So that's the only change.
If the board appreciates, like, one of the comments from the board engineer was asking for details that are typically provided with a map filing. You could subdivide by map, or you could subdivide by deed, and we're trying to do it by deed rather than a map filing. So if that's acceptable to the board, then some of the information requested in the review letters is not required.
No, I don't mean to interrupt, but the town prefers to have, maps be submitted for their records, maps that are signed in the end.
Even for like a two-lot subdivision?
Yes.
Yeah?
Filed in the county?
filed to us, for us to sign off on.
Oh, yes,
Yes, you
for
do have
for
to
the
file with the
township.
county.
Oh,
You
you
have-
get that, but this refers
I'm talking
to-
about the municipality.
Yeah, no, that's fine, we'll do that.
Okay.
But what this is referring to is if you could subdivide land by recording a map, a formal map with the county.
Right.
You know, with the vellum and all that stuff. But, we'd be happy to provide Parsippany, but this refers to like a county filing.
Okay.
And we just trying to, you know, save money by doing it by deed rather than by map. It's
So,
only 2 lots.
Steve, you would agree as a condition of approval that if you're going to file by deed, you'll send me a copy as the board attorney to review it and approve it before you file with the meets and bounds to be reviewed by the board engineer. It's a condition of approval, right?
Absolutely, and if I'm not mistaken, that the board chair and Nora will sign the deed
Right,
before it's recorded.
Right.
So you're gonna
yeah,
have.
one way or another, we're going to get it.
Yeah.
And you'll include with that a map for the municipal records.
Oh, yeah, the subdivision map will be, for purposes of resolution compliance, will be finalized and filed. Absolutely.
And you can skip the vellum.
Skip the vellum,
Okay.
the Mylar, whatever you call it.
Whatever. Vellum.
No one does the Mylar anymore.
Okay.
Yeah, on page 7, item 2 refers to impervious coverage. The driveway that we were just talking about on the new lot, we're going to have to include that impervious coverage on the impervious coverage table.
Well, if you're eventually going to remove the driveway, wouldn't that not be included under proposed conditions?
Yeah, it will be
Well,
removed.
They're removing it, but they're going to be replacing it with a driveway. This is kind of an awkward situation, you know, it's like,
We don't mind providing it. It's just a matter that it's temporal because that will be written up.
so, and I think the major point of that comment, number 2 and number 3, was we were not sure what was being removed. I think with this answer, I'm going to save the rest of my comments for Mr. McDonough, because I think we've eliminated most of the variances that we cited that were due to the driveway and the shed being removed. But to be brief, I'll wait for John.
That's fair.
Okay.
If the board has any questions, Mr. Matarazzo, then open up to the public.
Any questions from the board?
Yeah, I would like to clarify that if we're still leaving the driveway on the plans, that I want the impervious area to include that driveway. I understand it's being removed at some future date, but just to prevent any future confusion about what's out there, what's existing, that would still need to be one of the changes that gets made on the plans.
Yeah, acceptable.
Okay.
Are there any existing easements or protective covenants, deed restrictions, et cetera, on the property?
No, we submitted a letter from the property owner confirming that she had no knowledge of those, and then I myself went and did a impromptu title. I went back to the early 80s and found them. So I
Okay.
went back 40-something years.
Only 40?
Only 40.
Have any other approvals been received or applied for? Assuming you haven't.
Are there any other approvals at this stage of the process?
We did receive an exemption letter from Morris County Planning Board.
I can confirm that. That was one of the completeness items, and you provided that. So I'll
Yeah,
just thank you.
as far as outside agencies, none would be required at this point. Morris County Soil Conservation would be at the time of the building permit. So no, that would be it.
Thank you.
Thank you.
All right. All done with our engineer? Okay. Any members of the board have questions? Mr. DePiero?
Well, I just need clarification. Are we now going to approve this subdivision with the provision that that existing driveway be removed? Is that part of our approval?
We'd
I mean,
be
to
amenable.
answer
We'd
Jen's
be amenable to that,
question,
Councilman. We'd be amenable to, because again, the intention is to remove that driveway. A
does
new
that
driveway would
solve
be-
your problem if it's,
No, because then it's out of my control. If they're leaving it and the board gives them a condition, it is now the responsibility of the construction official and not the zoning officer, so I won't be doing anything with the driveway. If it's left as a condition to be the approval, then my construction official, it would be up to him to look at the plot plans and make sure it would be reviewed. It wouldn't be the zoning officer.
I think it's cleaner for us to do
Or
to
what if
approve
we
it with
put
the
as a
provision.
condition that prior to me signing the final as-built, the driveway must be removed?
That's
Because
fine.
then, if the driveway is not removed, I won't sign the final as-built, and construction can't issue it a CO.
Right, that's fine.
And then it falls, then I don't have to worry about it not being taken care of.
That works.
That's,
And that addresses our comment, recommendation on comment number 3, which goes from page 7 to 8, that we recommended that improvements not associated with the proposed lot shall be removed as a condition. I think it's been clarified, exactly what that would entail. So it seems it's yes to that one.
Yeah. And that would include the removal of the garage too. I mean, it's gonna be all.
Correct. So I think that clarifies it and it makes it easier for any resolution.
All right, does that satisfy our needs on impervious for O3 as well? Okay.
So to be clear, we can record the deeds for the minor subdivision with the garage still being intact, but not get a CO until we remove the garage?
I think the garage was
No,
intended to be removed.
I'm only talking the driveway. I do not propose any of the improvements that need to have a demo permit. That should happen before I even issue the zoning permit. So the structures would have to be removed prior to that. And then I'm only dealing with the driveway.
You indicated that the driveway was staying for staging purposes of construction. I don't think that that would apply to the other structures.
No, just the only thing I think, for purposes of timing, because we're trying to schedule a closing on this and then to record the deeds. So that's why I think we're trying to do, trying to get the paperwork and the closing completed sooner rather than later, to minimize the amount of construction required before the deeds are filed. That's the idea.
We've not,
The applicant is a contract purchaser, so he doesn't own the property at this point. The way.
Microphone.
The way his contract is structured is that at closing, he's gonna purchase 2 lots. And that's when they're gonna record the deeds, it's gonna be at closing. So for that period of time, the garage is still gonna be there until he closes.
so then at that time, he can demo, and then after that, come to zoning and construction for the permit.
Correct.
We could extend the 180 days required for zoning permit and give you more time to make those changes.
Yeah, so, but when he records the deed, which will be at his closing, that existing garage will still be there.
But we're not getting zoning permits until after.
Yeah,
Okay.
that's a decision of the engineer and the planner. Me,
No,
as
that's
the
fine.
director and zoning officer, I want those things gone before I'm issuing a zoning permit, so it's clean and
Perfectly
straightforward.
fine.
That's fine.
That's up to you.
no, this is all kosher. Any other board member questions?
Okay, any other questions from the board?
So just to clarify, if we approve this today, all we're doing is approving that the property will be split. That's it.
In essence, yes,
Yeah.
it's,
Not that this barn gets knocked down or any of that stuff, right? But these 2 barns,
Well, that's
garage.
one of the
is that
conditions.
part of it though?
right, so
Okay.
that's part of what that's part of their plan
Right.
to do based upon the colloquy with
Okay.
our zoning officer.
And in that way, the setbacks and variances that
Mhm.
would potentially be involved would have
Right.
been addressed.
All right, and we'll add all that at the end.
Yeah, I think we just need some very clear conditions about when each of these items is going to happen to make sure that they do happen. That way the board's clear on what they're actually approving here. It's not just the line, these other items need to be in there so that their structures are removed.
And can we clarify, once everything's removed and the new house, what those variances were? Because I'm even not sure now which ones
Right
were
now,
variances.
right now, the variances are strictly as to the lots, the lot width. It's, there is no variances being proposed as to, right now, the homes should be conforming, and if the homes are not conforming, we'll be back for the zoning board, presumably.
Yeah, and that's because you're removing the structures that would have been created a side yard variance.
Correct.
Yeah.
Right. Okay, this is just strictly to create 2 lots.
I think there was a existing front yard setback nonconformity.
And that will remain because the home is not being proposed for demolition just yet.
Okay, are we good as a board? Any other questions? All right, I'll open it up to questions from the general public for the engineer. Any members of the general public have questions? Yes, ma'am, please come forward. You'll need to give your name and your address.
You gotta take, we need a mic for the young lady. So-
There'll be
so-
opportunities to comment.
Yeah, so ma'am, just let me reiterate something that council just brought up. Now is the time to ask questions of the engineer, Mr. Matarazzo, about his testimony. If you have a statement with regard to the project, how you feel about the project, whether it should or shouldn't be approved, whatever concerns you have, that will come at a later point. So now is just questions for Mr. Matarazzo.
Oh, okay. My name is Edna Rada, and I live at
Can you pull the microphone closer, please?
I live at 239 East Halsey Road. I'm Lot 1 there on East Halsey Road. I just have a question. Have you considered, being that it's an old farmhouse, have you considered about how you're going to preserve the actual farmhouse, or possibly any artifacts that
Can you
might be
please
found
speak up?
Yeah,
in
be
the
close,
ground?
have the mic right in front of your face. I'm sorry, ma'am.
I know I have a very soft voice.
That's okay, just bring it real
Yeah, I was
close.
just wondering about, what's going to be preserved, because it is an old farmhouse, and the possibility that there could even be artifacts in the ground around the house itself. It's an very old property.
As part of this application, that existing house is to remain. So there's no demolition proposed at this point. The only thing would be on the right side of that lot is where a new house would go. And that's currently where there's pavement area.
Well, with old houses, a lot of times there, have been other structures on the property along with, and you might have old foundations or even artifacts in the ground itself that could be turned up during construction. Have you made
I
any
need you to speak up, please.
plans for that?
Actually, there's two existing foundations, if you want to call them, on the site. Those are proposed to be removed eventually. But as part of this application, it's strictly just subdividing the lots.
Thank you.
Thank you.
Historical that I know of, that's ever come up.
Any other questions from the public? All right, up, yep.
I don't know if it's an engineer, I was just wondering about,
Just gotta get, just, yeah, go ahead.
Lisa Gladstone, 3 Warwick. I'm on the corner of Warwick and Eastbrook. Just wondering about, the water tables, because it's kind of a hill and it runs down. So I was wondering like what kind of provisions are going to be put in once you start building that back house on that new lot, how you would make the water tables, to prevent any kind of flooding once,
So-
the ground moves. I know how that happens very quickly and it's already.
So this application is not about the construction of anything, it's about the subdivision of lots,
So just
and it's
subdivision and
just
not
subdivision with a couple of demolitions, which we discussed. But I would say this, that any construction
Mhm.
has to adhere to certain principles with regard to water, and that is that they cannot cause more water to come onto your property than currently happens. And in these days, as opposed to probably when this structure was built, there's a ton of regulations that any construction or developer would have to adhere to. So importantly, if at some later point if you were to experience more water than you currently experience now on your property, that's something you would then bring to the code enforcement of Parsippany to let them know that that is occurring, whether during construction or after the home is built. But in terms of what's being done tonight, they're not proposing any sort of development whereby they're saying, well, we're going to build something and this is what we're going to do. But there's a lot of stormwater measurements that are easily implemented these days for any new construction.
Okay. So there'll be like another hearing when they.
No, if they're,
You don't need another.
so if they're gonna build something on that lot that's compliant, meaning it sits within all of the parameters,
They just file.
they would file that with the building department and get their approvals.
Okay.
But regardless, there are statewide and local ordinances, state regulations with regard to construction code, and specifically as to stormwater controls.
Okay, thanks. So we'll just bring it to you, hopefully not.
Hopefully not.
Yeah. Any other members of the public? All right, seeing no one come forward, we'll close the public portion of the questions for the engineer. Mr. Tablakian?
Yes, thank you, Mr. Moderator. I have for my next witness, who needs no introduction, but John McDonough.
All right, Mr. McDonough, when you're ready?
I'm ready.
Always ready. Okay. Do you swear affirm and tell truth for the zoning, planning board tonight? Well,
Yes, I
you
do.
threw me off.
Yes, I do.
Okay. Mr. McDonough, can you please do us a favor of stating and spelling your name for the record?
Sure. Hi there, everyone. My name is John McDonough. I'm a licensed professional planner here in the state of New Jersey. My business address is 101 Gibraltar Drive. It's here in Parsippany, over at Route 10 in Powder Mill.
And Mr. McDonough, you've testified before this board and multiple other boards in the past with regard to your professional planning background. So unless you're going to tell us that your license to practice is not up to date, I would ask, Chair, that he be accepted in the field of professional planning.
Any members of the board have questions? Seeing none, witness is accepted.
Thank you, Mr. McDonough, you've done the planning analysis for this proposed subdivision. Can you, if you have any handouts you'd like to hand out, or let me know, I'll help you.
We'll start with the placemats, as always, and it wouldn't be a hearing with your council without the army of drones. So we'll have some drone shots of the subject property. As it's being handed out, we know that land use planning is not only isolated to the site itself, as you've seen through Mr. Matarazzo's testimony, but good planning looks at the greater context and how a development application lines up with the rest of the neighborhood. And that's the essence of what these exhibits are intended to show. Really what our applicant has done here, as he has done elsewhere in the community, is found a good spot and is proposing a development that is going to bring an existing site that in its context is not consistent with the neighborhood pattern, and proposing a subdivision here that will bring the site more in line with the neighborhood around it. And it's really 2 pages. I thought 2 pages was all I needed for this one. Sometimes I show more, but the first sheet shows it, and did we label it?
A2.
Okay, so A2 for the record shows the subject property outlined in yellow, and you can see right off the bat, it's the largest lot in the neighborhood here. I put in a little dash line to show where that proposed subdivision line is going to go, and basically balance out the site more in line with the other lots that we see in the neighborhood here. And when I took on this case, what I really liked about what our applicant was doing here was not taking down that charming farmhouse that's been there for a long time, but keeping it and sort of working around it, and a better alternative than one massive house here, which could be, if you look at the letter of the ordinance, could be a 12,000 square foot house, certainly entirely different than the home sizes that we see in the neighborhood. Here you have 2 lots that are more in line with the surrounding neighborhood context, keeping one house that's familiar in the local landscape. It's been there for a long time. I think that's laudable by our applicant. And then a new home site here that is going to be fully conforming with your ordinance in terms of front setback, rear setback, side setbacks, lot coverage, building height. Otherwise, we're back. I'm not asking for any relief in that regard tonight. The only relief is for the lot width on that lot to the right, the proposed building lot. which is going to be about 95% compliant. In the interest of working around the house that's there, we're moving that lot line, so we're going to be slightly askew of what the ordinance requirement would be. And that lot width variance is really the only variance that the applicant is asking the board to move on in terms of new variances. The front setback for the existing home is 50 feet required, and it's 15.3 now. The applicant's asking for that relief basically to keep what's there there. So we think there's both a practical difficulty and a public benefit in keeping what's there now in terms of an existing condition that's not changing and preserving a longstanding home in the community. Mr. Reinertsen, as always, has given the board a nice little scorecard here, if you will, in his report, very thorough. There are about 2 pages of zoning criteria here in the form of a table, and you can see over and over again, the applicant is complying, and that goes towards what I just said in terms of building coverage, lot coverage, building height, setbacks, all around, but for that little setback in the front where the existing building is. So this is a very clean application from a planning standpoint, but for that somewhat technical lot width variance where, again, we're 95% conforming. We're in the R2 residential district. The zone permits one-family dwelling on 30,000 square foot lots. We've got double that land capacity now, so we can cut this property up and have 2 conforming lots from a lot area standpoint. It's really only that width that the applicant is asking the board to move on. In terms of the justifications for relief, I'm not a lawyer, but planners operate in a legal framework. We've got some really good case law, which is almost right on point with what the applicant is doing here. It's called the Kaufman case, which is really the benchmark for what would be the C2 balancing test, where we look at the benefits of the application as a whole, substantially outweighing the detriments. Now, this Kaufman case involved a 2-lot subdivision that created not only deficient lot widths, but deficient lot area as well. So a worse case than we're dealing with now. Here we only have the lot width, the lot area conforms. The court in the Kaufman case ruled essentially that 2 smaller dwellings were a better zoning alternative than 1 massive dwelling, which would overpower the whole area. We also have a case known as the Green Meadow case. This was over in Montville, came out of the court in 2000, which is similar to Kaufman, except there the court reversed the denial by the board. Kaufman was the one that upheld an approval. So again, I just give this to the board as a legal framework that I, as a planner, have to look at. We've got similar facts here. The neighborhood pattern is well defined, and this follows that neighborhood. So in balancing, the benefits of the application as a whole would substantially outweigh the detriments. In terms of the public benefits, the Kaufman case found that, and this was a quote, improved neighborhood harmony was the basis for a C2 variance. Not only do we have the case law, but you've got the land use law as well, section 62, which says that zoning should revolve around the neighborhood pattern, which is exactly what this application does. Simple math, lot sizes that are compatible with the area ensure building sizes that are in scale with the area. So certainly a public benefit here is the creation of new housing stock and the preservation of existing housing stock, all of which go towards the land use law purposes of zoning under NJSA 40:55D-2, especially Purpose A, the promotion of the general welfare, Purpose D, to provide for appropriate population densities, Purpose G, to provide for a variety of uses in appropriate locations, Purpose I, the promotion of a desirable visual environment, again, retention of what's there, and a complementary new construction right next door. And then certainly Purpose M, our planning goal for efficient use of land, taking land that has been previously disturbed, cleaning it up, replacing that pavement with a new building pad. On the detriment side, I believe based on all the visuals you've been given, based on all the testimony, particularly from an engineering standpoint, relief can be granted without any substantial detriment here to the public or the zone plan. The degree of departure from the zone plan, which is something the board's always supposed to consider, is not significant here. It's, again, maybe 5% short. The reason why we have these lot width controls are really to protect light, air, and open space. And the applicant has done that here by, again, an application that I have not been asked to ask for any relief relative to setbacks for the new building lot. So I believe that that planning goal for light and air is met. In conclusion, the proposed subdivision is a better zoning alternative than a tear down and a new build. Most importantly, the statutory tests for relief are met and approval is warranted. That's all I have on the I didn't really talk about that second sheet, but that's the drone shot of the subject property. It is a nice leafy site, and if you look at it, the nice farmhouse is in the middle of the photograph near the road. The applicant is proposing the new building pad over by where that driveway is, and I think you have reasonable conditions that would protect when that driveway goes away. And what's nice, for the most part, that leafy area that you see to the left of the house is going to be intact, but for a new driveway that would cut through on the same side as the subject building would be in that lot on the left. So from a physical planning standpoint, I think this is a nice fit and integrates well with the overall neighborhood pattern. And that's all I have on the rest.
Thank you very much.
Okay. Questions from our professionals?
I guess it's my turn here. So, just for a cleanup part, on page 7, there's a footnote 3 that shouldn't be there. It's a stray. It talks about D variances. Obviously, if this is a D variance, we wouldn't be here. So we can just cross that out.
Council would have been right, that was in front of the zoning board.
Exactly. But Mr. McDonough, just to tie this out, since there, I mentioned if we can go to page 6 of our report.
Yes.
Okay, so what's before the board now is that they're going to eventually remove these improvements that are causing, like right now, if they kept the driveway width, it's too wide. They're going to remove it. So it eliminates that variance.
That's correct. That would be number 2 under lot point 802.
Yeah, and it is actually a typo there of the minimum driveway side yard setback because it encroaches. So I think that ties into our condition of approval about removal of the improvements and other, so.
I thought that was a good condition, yes.
Yeah, so the board's not approving any of this, so hypothetically, if they had to come back and they said, oh, we changed our mind about the driveway, no, we're not approving any of these variances tonight. They'd have to come back to the board for this, so.
That's right.
This would not be a one and done.
Correct.
So I think they both tie out. So basically, again, what you said is variance 1 on page 6 is the new variance.
That's correct.
And then lot 803, the side yard setback is eliminated because they're eliminating the shed. But you have the minimum front yard setback. And I think just as a bit, in the spirit of, I know this was a D2 variance with the Raspberry case, we do subdivision. I always say that the existing variance, yes, it exists, but I still call it a variance because when you're subdividing a property, in theory, you're increasing the intensity of the use. Okay, so, and I think your testimony covered that, but I just want to put down, I never call it a non-conforming condition in cases like this. I said, well, no, it's subdivided, so now it's a smaller lot, so we still have to provide the proofs, which you have.
Yes.
And that's all I have. He's answered the questions on item 1, it's satisfied during testimony. The applicant's engineer is addressed items 2 and 3, which dealt with these removals of the existing improvements. And he agreed to everything else. I don't think there's any other objections, so I have no other questions.
Okay. Any other questions? All right, questions from our board? All right, seeing none, I'll open it up to the public. Any questions of the planner for the public? Same rules as for the engineer, we're only asking questions regarding the testimony. Seeing no one come forward, I'll close the public portion and turn it back over to you, sir.
That's all I have, Mr. Chairman. Two witnesses, it's a fairly simple application.
Microphone, Steve.
It's a fairly simple application, very little relief, and the relief is, I believe, fully justified. Again, if the board has any further information, needs any further justifications, I have people here that can answer it, but it's
okay.
simple.
Well, at this point, we'll open it up to the public for any comments about this application. So feel free to share anything that's on your mind.
Not anything.
All right. Seeing no one come forward, we'll close the public portion. Is there anything else you'd like to say, sir?
That's all I have.
All right. Any comments from the board? All right, then I will entertain a motion.
Mr. Chairman, a motion to approve application number 26:506, Nakul Kasadwala, 289 East Halsey Road, Block 742, Lot 8, Zone R-2, minor subdivision with C variance, as
And with
per the conditions noted. Yeah.
With the conditions of approval, and I'm sure that Ms. Smith will correct me as I say something, but that the applicant will not have to record the map with the county. That will be done by deed with review by the board professionals. As another condition of approval, prior to the final as-built drawing approval by our zoning officer, the driveway must be removed.
Perfect.
And I just want to double check that. And that testimony was already provided, but we just want to be clear that the garage and shed will be demolished prior to the driveway and
Prior to the zoning permit.
prior to the zoning permit. You got all that, Steve? Good thing you do. I got to double check. All right, Mr. Deitch, is that okay with you?
That's good, yeah.
I knew
Okay.
it would be.
Do we have a second?
Second.
All right. Mr. Shaw. All right.
Didich,
Yes.
DePiero,
Yes.
Dinsmore,
Yes.
Hernandez,
Yes.
Napolitano,
Yes.
Patel. Yes. Shaw,
Yes.
Smith,
Yes.
Von Aiken.
Yes.
Really appreciate it. Thank you so much.
Thank you,
Have a
sir.
great summer.
Steve?
All right. That concludes our agenda for this evening. Would anybody like to make a motion to close? Or to adjourn? Yeah. That's it. Yeah. All right. Anyone opposed? No. So moved.
All right. Is Richie Brigadoro getting in trouble over there?
All right.
Good night.
Good night. I want to see you before you quit. Have a good day.